Just
Counsel, I want to sketch something out for you and see if you think it might work. Okay, so the government points out on pages 12 and 13 of its reply that if we agree with you about your B1 point, agree with you and the government about the B1 point, that it would be pretty natural, even if we disagree with you and agree with the government on the jurisdictional point, pretty natural to express agreement with the B1 point in the course of an analysis on the other. Okay, now let's say that and this is true, I do think there's something to this argument that the courts of appeals have made that E does not deprive them of jurisdiction to sua sponte have a panel hearing, rehearing en banc, or, sorry, panel rehearing or rehearing en banc, because it's really talking about the prisoner's inability to file such a petition or a petition for writ of certiorari. Okay, so this is what I'm sketching out here. Wouldn't it be possible if this court said in the course of the analysis, as the government proposes, that B1 is not incorporated, wouldn't it be possible for the 11th Circuit on remand to sua sponte correct its error? Wouldn't it be quite surprising, in fact, if the 11th Circuit didn't do that, sua sponte, if it has the authority under E, either by the panel or en banc, if we say that it is wrong in B1?
The problem with that, Your Honor, is that there will be no remand if the court dismisses this case for lack of jurisdiction. So we don't think the court should consider the government's proposal on page 12 unless the court totally rejects all of our jurisdictional arguments. That's the only—
That was the premise of my question.
Oh, okay, I'm sorry. So yes, then there would be no remand for the 11th Circuit to do that sua sponte rehearing that you suggest. And this is our concern here with this suggestion, is that it's even beyond that, which is that if the court tries to resolve the B1 conflict in the course of dismissing this case for lack of jurisdiction, we are concerned that the courts of appeals may perceive that to be dicta or worse, an advisory opinion. So if the court does consider that option, we would urge the court to be as explicit as possible on the B1 question, even to the point of saying that the reasoning on the B1 issue is a holding. Otherwise, what's going to happen is that if even one of the 6 circuits says, you know what, this is dicta, it doesn't abrogate our prior panel rules, and the 11th Circuit in particular has a very strict one, then we're in a situation where there's no way to get back up to this court on cert, and the circuit conflict will never be resolved. And then we'll have wasted all of our time, and this will all be for nothing. So I think the better way to deal with this, rather than that sort of very unorthodox approach, is to narrowly construe B3E as it has always done, as this court has always done, and directly resolve the circuit conflict over B1.
Okay, well, I don't know that that would be unorthodox, because we say things, we have alternate holdings, and we say things in opinions all the time that aren't directly relevant, but I take your point. Just one other question. The Chief Justice asked you about the constitutional avoidance on the essential functions piece, and you say that, yes, it would raise a constitutional question because construing this jurisdictional bar to be total would threaten the court's essential function of maintaining the uniformity of federal law. Why wouldn't that completely eviscerate the exceptions clause? Because it's possible to have a split on any question of federal law, right? So why could Congress ever withdraw our jurisdiction to weigh in on any question? Because even if a split doesn't exist then, it could always exist, right?
We're not saying that it wouldn't. A problem wouldn't arise in that situation. I think it's important to point out that this statute, B3E, is unique. There is no other statute like this. There are plenty of statutes that bar judicial review across the board, but there is no statute like this that targets this court's certiorari jurisdiction. And the problem that arises is the lower courts, the federal courts of appeals, are interpreting and applying EDPA. And if this court cannot superintend that and step in when there's a conflict,
so Congress can't, I mean, I take then the straightforward answer to my question is that, yes, Congress can really never deprive this court of certiorari to resolve questions of federal law, because that would deprive us of our ability to ensure the uniformity of federal law.
I think there's at least a serious question about that, and that's because whenever lower courts are deciding issues of federal law and this court cannot step in, then this court ceases to be the Supreme Court. The courts of appeals then become their own mini Supreme Courts. Thank you.
Justice Jackson.